Hello, my name is Ryan Campbell. I am an attorney in the state of New York, and welcome to Geek Corner. This is where I analyze copyright law, typically in geek properties. However, we're going a little bit generic today, because today we're going to talk about the requirement of human authorship in copyright and how that intersects with artificial intelligence. So to understand this requirement, let's go a little bit back into the case law. In the 1879 case, the trademark cases, the court elaborated that what intellectual property law is really meant to protect is the fruits of intellectual labor founded in the creative powers of the mind. Now, this assumes two big things that artificial intelligence does not have. Creative powers, it's just a thing that smashes stuff together. It doesn't create anything. And then of the mind. Artificial intelligence does not have what the court would have recognized at this time as a mind. Now, fast forwarding 5 years, we have a test of this precedent with Burrow-Giles Lithography Company v. Cerrone, where they're essentially asking how much human needed. What this means is how much creativity of a person do you need to add to an automated process for it to get copyright protection? In this case, a lithography company was printing out photos that were taken of Oscar Wilde. The photographer claims copyright infringement in this one, goes to the courts, and the courts find that the photographer does get the copyright. Now, keep in mind, this may be obvious today, but this was the 1800s. Photography was new. There was no case law on this point, essentially. So they found that in posing, lighting, and choosing the wardrobe of Oscar Wilde, that was enough creativity to grant the photographer a copyright, despite the fact that once he presses the shutter, much like once you enter a prompt in an artificial intelligence, the output, in this case, it would be a negative. In the case of artificial intelligence, it would be a script or a selection of images that you choose from would entitle that person or that photographer to the copyright. However, as of right now, they're not offering that to people that use artificial intelligence. We're going to get back to that in just a minute. But we also need to check out the fun monkey case. The monkey selfie case, Naruto v. Slater. This case was kind of a fun one where a wildlife photographer foolishly left his camera with a monkey. The monkey was literally monkeying around with the photo and having a great time of it. You see he's got this big smile when he finally snaps the photo accidentally, like. So the monkey selfie was run in a magazine, and of course, People for the Ethical Treatment of Animals, in a no way facetious or weird move, decided to sue on behalf of the monkey. The court ultimately held that the monkey had constitutional standing, go figure, but the monkey did not have statutory standing because the Copyright Act of 1976 has implied into its requirements that it be human authorship by cases like trademark cases and subsequent elaborations by the Copyright Office. Now, I would actually argue that a very elaborate prompt is far more creative than posing, wardrobing, and lighting Oscar Wilde. There are other creative factors that go into setting up a photo, especially in studio work. However, I get a copyright every time I snap a selfie. It is a very difficult argument that I could create a prompt as long and elaborate as the novel Ulysses and not be given a copyright because this, arguably, has less creativity than me bringing up my phone and snapping relatively mindlessly. You could spend a year just laboring on the perfect prompt, and you would be able to get a copyright, most likely at least, in the prompt itself. It's a written instrument thing. But the final product, because it goes through that automated process, does not, as of right now, qualify for copyright protection. I think that this is an issue that is ripe to just sprint up to the Supreme Court if it doesn't get handled legislatively beforehand, but good luck motivating Congress to do anything. As of right now, they can't even keep the lights on. This is going to be an issue at the heart of AI and the heart of copyright that is going to have a big question mark over it until it is solved. So I would really keep my ear to the ground because I kind of think that we're going to see some changes in this area very quick happen very soon.